important aspect related to employment laws, which historically has been quite archaic in nature. Earlier this year, the Parliament enacted four revised labor codes, primarily dealing with wages, industrial relations, social security, safety, and welfare conditions. While the government proposes to increase the ambit of social security by including gig workers and interstate migrant workers, fortunately, it has also proposed measures that will provide greater flexibility to the employers. So with a view to understand the new labor codes in a little bit more detail, IACC has partnered with Kochar & Co., one of the leading and largest corporate law firms here in India. We are very glad to have associated with them and partnered with them for this particular webinar. And I hope this benefits all the attendees and specifically all the IACC members. So first of all, I wish to welcome and introduce Stephen Matthias, who will moderate this session. Let me give you a brief introduction about Stephen. Stephen is the resident partner of the Bangalore office of Kochar & Co. Stephen is a graduate of the prestigious National Law School of India University, where he did an honors degree in arts and law. He is also a British Chevening scholar and has done a diploma in European and English law at the College of Law, York, and worked briefly at a leading law firm in London. He is also a solicitor on the rolls of the Law Society of England and Wales. He began his career working in the tax and regulatory division of multinational accounting firm Arthur Anderson, doing mergers and acquisitions, foreign investments, joint ventures, securities law, and strategic work. So very illustrious career. Stephen has extensive experience in the employment areas. His experience includes advising on non-compete and non-solicitation arrangements, termination of high-ranking executives, enforcement of employee bonds, risks issues with regards to reduction in force, and advice on privacy law issues pertaining to employee personal information. These are just a few. There are many other expertise areas in which he's very proficient in. So without further ado, I will hand it over to Stephen Matthias in a minute. Before I do that, I just want to announce a couple of quick protocols. So as a part of this webinar, all the attendees will remain on mute. Should you have any questions, kindly submit them via the chat application, and our moderators will pick up the questions and it will certainly be answered. So I look forward to a very exciting and informational session. So Stephen Matthias, thank you very much to you and your organization, Kochar & Co. For partnering with us for this webinar. I turn it over to you now to take the proceedings further. Thank you, Stephen.
Thank you, Shyam. Good afternoon, everyone. This is a fairly big legislative change for India, probably akin to the change in 2014 when we got a new Companies Act. We've had over 40 odd legislations in the employment and labor space, and these are now being replaced by these four codes. The first one was the wages code, which was enacted last year, and the balance three were enacted recently. These have not yet come into force, and it's expected to come into force on April 1st, 2021. And that's great because it gives everyone time to digest what's there in these new laws. Essentially, the intention is to simplify and to modernize labor laws in India with an emphasis on ease of doing business. We'll have to see whether the codes actually achieve that or not. We're going to start by discussing the wages code, and we will have Suhas Srinivasaya take us through that. Suhas is a senior partner in Kochar & Company. He's a corporate regulatory and employment lawyer. And above all, he assists foreign companies in setting up and operating in India. His practice covers a large number of areas from corporate, employment, real estate, all kinds of regulatory issues. And essentially, he is someone who understands the pulse of foreign companies, particularly American companies doing business in India, in terms of what are the key legal and regulatory issues they face operating in India. So over to Suhas on the code of wages.
Thank you, Stephen. Just nod if you can hear me well. Okay, great. Good afternoon, everyone. It's a pleasure to be here today. So I will start with the first code that was actually enacted in 2019, which is the Code on Wages. The rules were framed recently, but this law was actually passed by the Indian Parliament last year itself. Now, this law is kind of simple in its ambit, in the sense that it consolidates 4 key legislations relating to payments to be made to employees, which is the Payment of Wages Act, Payment of Bonus Act, the Equal Remuneration Act, and the Minimum Wages Act. Now, I will focus a little less on the Minimum Wages Act because the audience here is, I would expect, largely a corporate audience, not really impacted by the changes to the Minimum Wages Act. But one thing I will mention about the Minimum Wages Act before I get into the other legislations is that under the new code, the central government has now taken upon itself the power to frame what is called a floor minimum wage. So no state can actually frame a minimum wage lower than the floor price or the floor wages that the central government will put into force. So that's really the key change in from the previous Minimum Wages Act. Now, under the Code of Wages, the central government has also framed the draft central rules, which actually kind of now consolidate 8 different rules which were in existence under the previous regime. The draft has been put up on the Ministry of Labour, Government of India. It is open for public suggestions. So, you know, if any of you have suggestions, you're welcome to send them through to the government. We put in a few as well, and I will mention them a little later. But as of now, the rules have not been promulgated yet, but the draft has been put up on the Ministry of Labour. Now, one of the first things that the Code on Wages seeks to achieve is, you know, it wants to bring in uniformity amongst different concepts that exist or existed under the existing previous regime. So, for example, the definition of wages under the Payment of Wages Act and the Minimum Wages Act is kind of different. And in fact, even in the bonus calculation, the wages calculation included certain components within its ambit, excluded certain others which were in the Payment of Wages Act. So one of the first things that it seeks to do, which is a good thing and a welcome change, is that now there will be uniformity in the definition of wages. There will be uniformity in concepts which will be applied across different regimes under the ambit of the Code on Wages. The other important change that the code does is, for the first time, it defines a category of workers called employees. Now, under the existing or previous regime, there was a distinction between workers and non-workers. And sometimes, you know, senior management officials were not within the ambit of workers or non-workers. So it could be held that they were at a disadvantage, so to speak. So now, you know, a new category has been introduced called employees, and most payment obligations relate to employees. And the definition of employees includes even managerial and supervisory employees, as well as employees in administrative roles, managing an office, and so on and so forth. In terms of what the law has changed, the substantive aspects remain more or less the same, but it does achieve a certain level of simplification and consolidation of different concepts under the four legislations that have now been clubbed together. So, if a quick example is that there appear to be only 60 odd sections, including some sections which repeal the previous laws. And in the central rules, there are just 50 odd rules. So in a sense, it is much easier to read this code compared to the existing regime. Now, the simplification is also in terms of compliances. So now, rather than having 10 registers under the existing regime, the new regime requires employers to maintain just 2 registers. And from 4 filings or returns that had to be done under the existing regime, the new regime requires that only 1 return, 1 consolidated return to be filed with the labor authorities. Now, one word of caution here, though the expectation is the code will result in simplification and consolidation, there is a power given to state governments to frame separate rules. So hopefully the states will tread very carefully here and will not complicate the code by framing separate and distinct rules across different states. And it will be limited to a federal or largely to a federal or central legislative regime. Now, the first important thing that struck me when I read the code, which I thought was very interesting, is earlier there was a certain amount of fear when it came to labor authorities, especially the inspectors who would come and inspect or issue show cause notices to employers and so on. The first thing that struck me is the inspector definition has been changed to somebody called an inspector cum facilitator. And it specifically says in the definition of inspector cum facilitator that his role also includes advising employers and workers on compliances to be undertaken under the code. So hopefully the authorities will have a mindset change, and from being driven towards picking mistakes committed by employers, they will move to a situation where they will actually become facilitators in the new regime. The second very important thing that struck me in the code is that the code now introduces something called web-based inspection of records and web-based calling for information. So hopefully, what the government has done under the income tax law, which is spaceless assessments, will carry forward to the labor legislations as well, whereby due to the spaceless interaction, it may reduce chances of corruption, unjust harassment, and so on of employers. And we will hopefully see a smooth interaction with the labor authorities in days to come. Now, one of the many things that, one of the key things that my clients asked me in the past 20 years was, perhaps I committed a labor law violation, but for me, this is a technical offense. And you tell me that I can go to prison for having committed a labor law violation. Perhaps I didn't pay my wages on time. I delayed by 1 day. I didn't make an overtime payment. So is it really that for a financial mistake that I committed, I should go to prison? So the court has sought to fix this, and it has decriminalized several offenses which existed under the existing regime. So now more or less all offenses are dealt with penalties. The penalties were rather low previously, but now the penalties have kind of increased from 10,000 rupees to 50,000 rupees and so on. And there is also opportunity which has been given to employers to compound offenses. Now, compounding is a process that many of us are familiar with under exchange control laws and under company law and so on. So basically, compounding is telling the authority, yes, I committed a mistake, but I will pay a fine, and please excuse me and don't prosecute me for this offense. So the code has introduced company law type compounding for violations of the code on wages. And the compounding fee to be paid has been prescribed to be a minimum of 50%. It's up to the authority if they want to put something more than that for compounding. But compounding is not available if the offense is committed again within a period of 5 years from the date of the first offense. So that's another important thing to be noted. The other important thing to be noted is in some form imprisonment still exists in the sense that if the same violation is committed within 5 years, then the court prescribes imprisonment of a maximum of 3 months as well as a fine. But going by criminal procedure code, if the imprisonment is less than a year, then usually it becomes a situation where the court may well say that there's no need for imprisonment, but you can pay a fine and be done with it. So that's another welcome change. In terms of the definition of wages, for the first time, the government has introduced a very interesting concept, which is, they tend to say that wages should be up to 50% of the CTC, of the cost to company. And if you are providing allowances and expenses which exceed 50%, then the percentage which is in excess of 5% or 50% will be deemed to be wages. So, for example, how this plays into effect is the code on wages for the first time, which was earlier a state concept covered under the Shops Act or overtime, says that now overtime has to be paid at a minimum of twice the normal wages. So if a company is having expenses or allowances exceeding 50%, then the delta above the 50% will be considered and deemed to be part of wages. This is a new introduction under the code. Many times my American clients ask me that, we want to pay salaries twice a month because that's in line with our global practices. So for the first time, the code now says that the wage period need not be a month. It can be daily, it can be weekly, it can be fortnightly or monthly. So this will give, so you can pay wages as per what has been fixed as the wage period. So this will give flexibility to MNC companies to perhaps pay weekly wages or fortnightly or monthly wages to their employees. Salary payments can be made electronically under the code, but the law has now stated that certain notified sectors should only make electronic payments. So what I'm expecting is perhaps for the IT industry, it will now specifically be a requirement to pay salaries in electronic form, which is probably already happening, so it may not be a huge compliance problem. Earlier, full and final payments, full and final settlements for separating employees had to be paid within 2 days if it was a termination, but resigning employees could be paid as per the next pay cycle. But now the law is going to change, which is a very key change, which is full and final settlements should be made within 2 days of resignation as well. And this is a stipulation as per the code. In terms of claims by employees, claims in the nature of wages not being paid, overtime not being paid, and so on, the earlier limitation periods were between 6 months to 2 years. The limitation period to make these claims have now been extended to 3 years. And the burden of proof has been imposed on the employer to prove in a claim that they have actually made timely and accurate payments as required under the code. So this is a key change that employers should note because it is now up to the employers to prove that they have made timely payments. So that's really the key changes under the code on wages. So unless, Stephen, as the moderator, you have something specific to ask on the court, we can move to the next topic.
Yeah, Suhas, what about the Payment of Bonus Act? I didn't hear you say much about that. Is that concept of payment of bonus, is it still there?
Yes. So under the code, the existing Payment of Bonus Act has been subsumed. But unfortunately, unlike the payment of wages or the minimum wages, not much clarity has been given under the code for payment of bonus. The thresholds remain the same, nothing has changed. The applicability of the bonus payment is also retained at 20 employees, but the salary limit has not been notified. So presently, under the Payment of Bonus Act, it's mandatory to pay bonus for employees earning up to 21,000 rupees per month. So that threshold has not been notified, and otherwise, everything else remains the same under the Payment of Bonus Act.
Okay. One aspect of wages is the concept of equal remuneration. So we've had this equal remuneration legislation in the past. So does the law deal with that? And also, how does it? Is there anything promoting women in the workplace?
Yeah. So yes, the code also subsumes the Equal Remuneration Act provisions. One very heartening change that I noticed was that Indian law seems to be moving away from a focus on male and female. So for the first time, I saw that the Equal Remuneration Act provisions under the code deal with all genders. So it specifically now covers transgender people as well. And it says that no discrimination should occur between genders, which is a welcome change that I see in the legislation. In addition to that, again, more or less the existing provisions have been retained under the new code. But a welcome change that I saw is when it came to same pay for equal work for equal skill. One interesting addition is the addition of the word experience as well. So there cannot be discrimination anymore for people performing the same work with the same level of experience. So that is the other key change that I saw in the new provisions under the Equal Remuneration Act. Now, coming to the women employees question that you asked, very heartening to see that under the code, the code envisages having a central advisory board as well as a state advisory board. And it says by legislation now that 1/3 of the members of such boards should be women. And one of the tasks given to these advisory boards is to recommend employment opportunities for women and how to increase these employment opportunities. So I think, if the board works as expected under the legislation, we would see far more increased women employees at the workplace. So I think that's another very heartening change that I see in the code.
Okay, great. With that, we'll move away from the wages code and move on to the industrial relations code. Debjani Aich is going to take us through that. Debjani is a partner in our Bangalore office and heads our employment practice in Bangalore. And she advises clients on all kinds of employment law issues, whether it's employment contracts or benefits, termination, and so on. One fairly sensitive task that she takes up is to handhold management through reductions in force, which is a fairly sensitive issue. And another is she is well known for her expertise in sexual harassment, in prevention of sexual harassment. She speaks at conferences, does trainings, and more importantly, she's a member of the ICC for many of our clients and handles some fairly sensitive sexual harassment cases. So over to Debjani for the Industrial Relations Code.
It's always fun to jump into industrial disputes straight from money, isn't it? Am I audible? My first assembly, just nod and say that I'm audible. Yeah?
Yes.
Okay, great. Thank you. So what I'm going to do over the next 10 odd minutes is try and do a deep dive into the Industrial Relations Code, which again came out in October of this year, and to see how laws dating back from the 1920s have now all been jumbled together in what could have been a more effective form of labor reform, to see how you're handling something as important as industrial relationships. Is it okay just to pull laws from 1926, 1946, and 1947, combine them together and see how that works? So the way I intend to handle the next few minutes is to break down important components of the Industrial Relations Code, how it will play out and how it's different as such from the existing laws, which are the Industrial Disputes Act, the Industrial Employment Standing Orders Act, and the Trade Unions Act. I will spend a little bit more time on the industrial disputes and standing orders aspect, as that is quite important for the current audience. We will also look a little bit at trade unions, because personally for me, when you're looking at labor law reform and the opportunity that the government had to go through with a code without consultation with workmen and unions was something that was not really expected. And there has been considerable pushback from trade unions, from workmen's organizations in relation to the fact that they have not really been consulted, and whether when you're trying to make it easier for employers and you're trying to make it easier to do business in India, did we forget about workmen's rights? The answer, what I believe, is no, but I think that things could have been handled in a more nuanced fashion. We'll go through a little bit of that as we go through the next few points. Interestingly enough, the first thing that happened was, we've had the term workmen. Now, Suhas talked about the fact that we're looking at a little bit more gender neutrality, more inclusion. So we've dropped the term workman to replace it with worker, which is great. But the definition pretty much remains the same as the Industrial Disputes Act. Essentially, anybody who is doing any kind of work, who is not a manager or in an administrative capacity or a supervisory capacity, now earning up to 18,000 rupees a month, is a worker. So this is literally no change to workmen other than the fact that you've hiked up the salary. Given the fact, especially right now when we're all coming through a pandemic and we've seen the nuanced subtleties that are coming to the workspace, a little bit more emphasis and thought could have happened. But for your understanding, if you're not a manager or you're not an administrator or you're not a supervisory worker in your key roles, you are now covered by the IR code. A fixed term employment. This has been floating around for a while. It came in under the Industrial Employment Standing Orders Act, but now the IR code firmly brings it in and makes it applicable to all sectors. The aim of introducing fixed term employment, funnily enough, what I read somewhere is that certain aspects or certain folks in the government believe that millennials need to jump jobs. And so fixed term employment is a great way to go. Obviously, for an employer's perspective, having a fixed term employment where you're not looking at, earlier in the earlier space, you did not have to give them social security benefits, gratuity was not applicable. The good thing now is that fixed term employees have parity in terms of employment working conditions, irrespective of the tenure. So from an employer's perspective, key financial aspects that you need to remember and note is social security and gratuity, which was not accounted for earlier. A key takeaway from fixed term employment is that the retrenchment obligations that apply to workmen under the Industrial Disputes Act or to workers under the IR code will not apply to fixed term employees, which means you can actually go ahead and terminate a fixed term employee once his contract expires without the requirement of going through the retrenchment process. Mainly, you're looking at aspects like compensation and the notice period. So that really does give flexibility to employers to maybe go down the fixed term employee route. Will this actually lead to an isolation or non-recognition, or is it an easier way to work? That is something that we'll have to see. Also to see how employers will adopt this method of employment. The grievance redressal mechanism is an often overlooked clause within the Industrial Disputes Act, which essentially looks at helping employees or workers address specific individual grievances. What the IR code now says, that there is a format under the IR code. The good thing here is that it has equal representation from workers and from the establishment, and the IR code the rules have just come out just about a couple of weeks back. So what the rules say, that it needs to have proportionate representation of women on the committee now, which is again a move towards making the workplace more inclusive and more diverse. The rules, now when I'm talking about the rules, in my opinion, could really have been more simplified. One expected something more streamlined. There have been no substantive changes to the rules other than kind of amalgamating them all together. There has been some streamlining in terms of filings, compliances, moving towards digitization. All of those are great moves. But honestly, if you're looking at it from a procedural perspective, there really hasn't been that much of a change. Coming to something that the media has been talking about a lot. Across the media reports, many media reports have been saying that prior government approval for termination of an establishment has now, from 100 employees, has now gone up to 300 workers. So this actually correlates to Chapter 5B of the Industrial Disputes Act. Something that's really important for you to remember is that these provisions apply to specific establishments and not to all establishments per se. This threshold requirement applies to factories, mines, and plantations. This is exactly as it was under 5B of the Industrial Disputes Act, wherein if you are a factory, mine, or plantation now under the code, you need prior government permission to close down an undertaking, to lay off workers, or retrench workers. All other requirements in relation to these processes, in which when we're talking about retrenchment compensation, we're talking about notice period, all of those other provisions remain as is. So this is something where we need to spend a little bit of time. So what this provision actually does is it allows smaller factories, mines, and plantations with less than 300 workers to go ahead and terminate without prior approval following the process. But it really doesn't impact other establishments. And that, I think, that confusion has been created again with the fact that the definition of worker has not been substantively modified as such. A worker is still a worker. Now we're just talking about factories, mines, and plantations with 300 or more workers where we need prior permission. A similar increase in threshold has been seen for the applicability of standing orders. So under the Industrial Employment Standing Orders Act earlier, if you had 100 or more workmen, you needed to get the law was applicable to you. Now the requirements under the IR code talk about industrial establishments with 300 or more workers, where they are required to prepare standing orders on specific listed matters, essentially talking about working conditions, the right of misconduct, disciplinary proceedings, employment termination. Now, by increasing this threshold to 300 workers, again, it is giving covered establishments flexibility to hire, flexibility to fire. There is no requirement for prior government approval. You can do what is required under the standing orders. The standing orders, now there's a draft of model standing orders that are there. If you're following the model standing orders, you're good to go. You don't need really any certification. It's deemed certification. If you are deviating from the model standing orders, that's when you'll need certification, and the entire same process of consultation with workmen, making sure that the notices go out, things like that continue to apply as is. Here again, I have a little bit of an issue. Now, if you recollect, especially from all of you who are working in Karnataka, we've seen the exemption granted from applicability of the IASO Act to the IT/ITES sector, subject to various conditions. Now, when you're looking at a labor law reform, that obviously means that you could have considered these aspects. And this also means that states, as Suhas had mentioned earlier, states now may also legislate and create new rules, new exemptions to modifying, varying, or amending the applicability of these provisions under the IR code. I'm not really sure how this is going to work out. I know that there is there's a lot of consultation that will be required with the state governments to see how much flexibility we are going to get when we're looking at amending these, or not amending, but at least in introducing new state laws that relate to these provisions. It is going to be a bit of a task to harmonize something that could have been done a little bit better. When we're going to the whole concept of labor law reforms, when we're looking at streamlining working conditions, using archaic models is something that could have been avoided. Now we're looking at state governments to see whether they're going to actually modify or change these by way of new state rules or exemptions to see if this works at all. Like I mentioned at the beginning, there was minimal workmen consultation when the government drafted the IR code, as compared to the previous drafts of the bills where there had been some amount of consultation in the attempt to ease doing business. And that's a great thing. There has been some degree of curtailing of workers' rights. Now, what has happened, and a key example of that is seen in the strikes and lockouts, wherein earlier notice was required to be given for workers in public utility services. Now, this notice requirement applies to all establishments. So a workman in any establishment cannot go on strike without providing the required notice. In a way, this will make sure that you can't have flash strikes, which is great from an establishment's perspective. But it mildly dilutes the whole concept of collective bargaining. I believe that it will, hopefully the way companies are working, the way manufacturing units are working, we will have a more cordial, harmonious environment. But the entire pushback that has been seen on the IR code is flowing from these provisions, wherein you have kind of curtailed rights to strike, rights of collective bargaining, and it's something to consider. Again, trade unions, largely invisible so far in most of the private sector companies, mostly in the manufacturing sector. But we are seeing the bargaining of trade unions in the IT sector, ITS sector over the last 2-3 years. They pop up, they're registered, they kind of disappear, they're floating around for a bit. But there is really no streamlined process other than the fact that they reach out, especially in cases of terminations or contentious retrenchments, things like that. So what the IR code now has kind of categorized that there has to be a specific negotiating union, the trade union that can actually bargain or discuss with the establishment needs to have 51% of the workers as members, and that is the only negotiating union. This, in effect, reduces the negotiating, it actually does help simplify aspects because you're not talking to multiple registered, unregistered unions, you have one union. But the union, again, has to have 20% of the workers in the establishment need to be part of that sole union. Again, definitely helping companies to run, definitely making sure that the collective bargaining process is smoother because you're talking to one union as compared to multiple disputes or charters of demands that may be raised. But just from my perspective, I think that just narrowing it down to one union has created a lot of pushback, and we'll have to see how this plays out. E-filings, brilliant. It's come in very well. It's been all the rules also talk about the fact that you can file everything electronically, which is great because, it's impractical. And I hope this actually goes through in a proper manner right now. We've seen some examples of states like Telangana and Andhra Pradesh, which have absolutely beautiful methods of e-filing. So this is something that was really required. The dispute mechanism has been streamlined, wherein we removed, the IR code has now removed the Board of Conciliation, the Court of Inquiry. We're looking at state-specific industrial tribunals and a national industrial tribunal. So each state will have one industrial tribunal right now. So disputes will need to be routed through that. Again, this is a way, and in fact, the law talks about 90 days within which these matters, there is a timeline under which these matters need to be resolved. So it is a method to streamline the entire dispute resolution process. Labor courts have been notoriously slow and overburdened in handling all these matters. Conciliation has not really proved to be very effective. So the streamlining of this process is something that is a good move. Penalties have been bumped up. I mean, whoever's looked at the law knows that 100 rupee fine under the Industrial Disputes Act really meant nothing. So the penalties have gone up substantially to almost, going up to 2 lakh rupees, which is a really, really big hype. And compounding of penalties, as Suhas mentioned, is now possible. There are various conditions that are there, depending on the type of offense that is there, whether it's a repeat offense or not, and it's subject to depositing a certain amount of money, about 50% of the amount, with the concerned officer. A very interesting clause that I found in the IR code was the exemption. The government has a right to exempt an industrial establishment in public interest. Now, public interest has not been defined, which means that the government has a lot of leeway now to determine how the code applies, which provisions of the code apply, which classes of establishments are covered. I am looking forward to the next year to see how this is actually going to play out, because there will be industrial pushback on something like this. Public interest is a very broad term, and it gives the government a lot of control. So this is an interesting provision. We'll see how it plays out. Okay. Yeah, I'm wrapping up here. I think I'm keeping on time.
Devjani, help me crystallize my understanding here on retrenchment, because I think that's probably the most sensitive issue for clients. Also keeping in mind, possible movement of businesses from China to India and incentivizing manufacture in India and so on. There's this talk about free mobility of labor and what you call hire or fire. So the way I understand it is, if you're a factory, mine or plantation, and you have more than 300 workers, then you need government approval in order to retrench as well as to close down.
Yes.
If you're a factory, mine or plantation with less than 300, then you don't need that. Or if you are not a factory, mine or plantation, such as say the IT industry or most services industry, then again, there is no government approval to terminate or to retrench or to close down. Is that correct?
That is correct. And that also came as a little bit of a surprise to me. And I think to a lot of people in the HR space and in the legal space, also from an operational perspective. So there has been no substantive change as such to the termination process, the retrenchment process for workers, other than increasing the threshold to 300 workers for factories, mines, and plantations. The same requirements for notice period, retrenchment compensation, and approval continue to apply when you have 300 or more workers. So the target audience as such, Stephen, is smaller establishments, not big establishments at all.
So you want to set up a factory with 1,000 workers, you want to terminate, retrench 1 or 2 workers because you don't need them, you need government approval.
That's right.
Okay.
So while you're saying doing, ease of business, any manufacturing facility with less than 300 workers, any 300 workers is a very low threshold. It's a small establishment. It's not a big establishment.
Now let's look at the retrenchment benefits. Typically, so what we are seeing here, the law is pretty much the same, but there is one major change. I think it's there on paper in the current law. Correct me if I'm wrong, which is the fixed term employment. And what that means with fixed term employment is someone is there for a year. The year expires, and you tell him, sorry, I'm not going to renew. And that means that you don't have to pay him that retrenchment compensation, 15 days for every year worked and so on. And this is the other issue which kind of disincentivizes businesses to allow for tenure. Because the more the tenure, the longer you stay there, the more years you're there, the higher you have to pay if you want to retrench that person. So if you do a fixed term, then I guess you can avoid that. But then the question is, can you keep on renewing that fixed term?
The
Isn't
law,
that subject to abuse? And wouldn't it have been better to have just had a fixed retrenchment compensation, like 1 month or 2 months, regardless of your tenure, and then not have the fixed term, option?
So the fixed term employment concept comes with its own share of issues. The IR code does not talk about the duration of a fixed term contract or fixed term employment. We're looking at judicial precedent in the past, which gives suggestions as to how long a fixed term employment contract can continue. But in the current context, there is no prescribed renewal term, which means that you could, have it expire and then renew all over again. And in a way that gives, you're looking at keeping costs down by not having to pay retrenchment compensation, but you're also losing out on skilled workers. That is a key thing that, how many times are you going to fire junior level folks or mid-level folks? You want to keep them on a fixed term contract. You keep them in, you fire them after 4 years. What then you're going to bring them back? It's not the ideal approach to make sure that business is running smoothly or continuously with the right set of skill set.
Right. Okay, I must I can't conceal my my disappointment to some extent. I asked the fundamental question, which is in 2020, do we need to have a law which requires government approval to terminate or to retrench even one workman, especially if you're giving him the social security, the retrenchment compensation, and so on. So I think that's one area of disappointment for me with this code.
Yeah. And I think another thing, again, flowing from what you're saying, uh, we're looking at government interference again. We're looking at delays. We're looking at loss of productivity when we're waiting down. Or say economic loss, you need to close down quickly. You've got 301 workers. I still need the prior government approval, but I've been making losses for 2 years. How quickly is that going to come through? It's notoriously difficult to get these approvals. So it is controlled. It actually does work out to control.
Right. Okay. Let's move on to the Social Security Code, and let's hear what you have to say about that.
Okay, so I'm going to continue a little bit more here. So we're jumping from money to industrial disputes, and then we move on to social security. And why the social security code, the code on social security, has become even more important over the last 8-9 months where we're facing the pandemic is I think that the common man has now realized, or at least is reading about, the crores of employees or workers who are not covered by the basket of social security at all. Social security so far under India has been based on employee thresholds, has been based on wage ceilings, but it has not recognized, it has not looked at the unorganized sector. So the greatest or the best part about the social security code for a lot of people is the introduction and the coverage of the unorganized sector under the code. Very honestly, there have not been too many substantive changes that I see in the Social Security and amalgamated key laws. And of course, introduce some very good things. There has been rationalization, there has been harmonization, which will assist. A lot of stuff has still been left open to notification, to government input, to state government, possible state government intervention, which leaves it a little open-ended. What I will be doing, so what the code is doing right now is it's looking at 9 central laws that you can see. What I will be talking about are the aspects under the fund, a little bit of the Employees Compensation Act, the State Insurance Act, Maternity Benefit Act. Those are the key ones that I want to be able to cover over the next 10 odd minutes. And the way I structured it is a little bit of a comparative analysis. So you can see what was there earlier under the various laws and what currently applies. Good things that have come in are rationalized definitions, introduction of system, a more systematic approach rather than looking at 9 codes to see who an employee is, what wages are, who an employer is, who an employee is, what contract labor is. All of that is now more streamlined. The wages definition is more or less the same as what you see under the Code of Wages. There are, however, again, when you're looking at reforms, at least you can look at a little bit of tighter drafting. There are some gaps in the codes, they didn't have to be so bulky, first of all. There are gaps in basic drafting the codes where there are plurality of definitions. As you can see, factories has been defined under the OSH code. You've used the old definition of factory under the Social Security code. So I'm not really sure who's been doing the drafting. Could have been a little better. It would have made all our lives a little better if this was a little tighter. I'll jump straight to Provident Fund. The eligibility criteria remains the same. It applies to establishments with 20 or more employees. The contributions have gone down to 10% as per the current as per the current code, but the central government can increase it back to 12%, which it currently is. The government also has retained, there are certain pandemic rights that are given to the government to play around or to modify or amend the provisions of the Social Security Code depending upon exigencies like the pandemic. So if you all recollect, in May 2020, when we were at the peak of the pandemic, the government had reduced the PF contribution to 10% for most establishments other than the government establishments for a few months, for I think it was May, June, July. So that right continues to remain with the government. The other substantive provisions of the Provident Fund Act remain as is. A key change that I have observed is on the appeal process, wherein it's a little bit of, again, a dilution as such of the right to appeal. Sorry. Just give me 1 sec. Right. So earlier, earlier a right of appeal as such has been curtailed right now, where a person who's only been aggrieved by order passed relating to the assessment and determination of dues can now prefer an appeal, which is a narrowing down of the appeal process. I'm not sure as to why this has been reduced as such. It's always been comforting to employees when we're looking at something like Social Security benefits to be able to raise an appeal for anything, whether it's a notification or an order. Curtailing an employee's right to only determination and assessment of dues is, I want to see how this is going to play out. Very honestly, I want to see how this is going to play out. Where do employees go if they have a concern? It is not very clear under the Social Security Code or in the rules so far. Now, talking about state insurance, I think one of the biggest gaps that came in during the pandemic was the lack of a good health infrastructure. The ASI Act provisions as such remain unchanged under the Social Security Code. The eligibility criteria remains the same, 10 or more employees. What the Social Security Code has now done is it has also now includes establishments carrying out hazardous or life-threatening work notified by the central government. Again, we are looking at notification by the central government to let us know what is life-threatening work. The contributions more or less are more or less the same. The contribution rate is 3.25% for the employer and 0.75% by the employee. There really have been no other changes to the ESI provisions other than, just making other aspects like overall, just making sure things like definitions have been harmonized. So you're not looking at multiple laws to understand what wages are, who the employee is, who an employer is, contract workers, interstate migrant workers. All of them are now covered under the ambit of the Social Security Code. Gratuity, again, there's just about 3 sections on gratuity, which makes it really easy reading. Gratuity applies to establishments with 10 or more employees. This continues to remain as is. The term for payment of gratuity also stays at 5 years, but there are some exceptions as seen for working journalists where the attrition rate is slightly higher. Again, going back to the whole fixed term employee concept, fixed term employees are now eligible for gratuity. That is something that needs to be remembered also under the Social Security Code. The gratuity cap was earlier 20 lakhs under the Payment of Gratuity Act, and now will need to be notified by the government. Aspects like the mode of computation, the withholding of gratuity for misconduct remain broadly unchanged. What I recollect is now that the sexual harassment, I think, has been specifically called in, where you could probably withhold gratuity in case an employee has been found guilty of sexual harassment. The maternity benefit provisions are more or less flowing from the Maternity Benefit Act amendment that took place, and has brought some degree of clarity, especially when you look at the rules, some degree of clarity as to how you're going to actually handle this process. The maternity benefit provisions continue to apply to establishments with 10 or more employees. Things that are, key aspects that have changed is that there was earlier a medical bonus of 3,500 rupees that needed to be provided by an employer who was not providing any maternity-related medical care. The requirement for payment of this medical bonus remains the same, but again, it's open to notification by the government. A very, very important move or an introduction that was not there under the Maternity Benefit Amendment Act was the fact that employers can now pool the resources and set up a common creche facility or use a private creche. Now, I know a lot of my clients have really been miserable about trying to figure this out logistically and from an operational perspective because they don't have the space or there is no proper creche that meets the requirements right now. The fact that the code actually says that you can use a private creche is a good move. The rules, however, continue to be ambiguous. They've talked about, distance, which is easily accessible, that should take 5 to 15 minutes to get there. You've got a nursing break for 15 minutes. You need to get the woman, the woman needs to go there to meet her baby. How'd she get there? What is this appropriate distance? All of that has still not been specified. So we're going to have to, again, depend upon states to form rules that are more practical into actually implementing these provisions. I won't spend so much time on employees' compensation. Just for your awareness, most of the provisions are substantively the same. They apply to specific industries and categories of workers. There are extensive and exhaustive schedules to the code that talk about all of this. I would suggest, if you just take a look at it at some point of time, there have been no substantive changes as such to the Employees' Compensation Act provisions. Now, this is the interesting bit, the unorganized sector. I think the government was hit with a barrage of extremely bad publicity during the pandemic about the fact that nobody really cared about the people who are walking home. There was no care, there was no system, there was no healthcare facility. There still isn't anything, but at least the government has now made proactive moves towards at least recognizing this whole sector. So what the law now talks about is gig workers, home-based workers, platform workers, all very interesting definitions. They rotate around the whole concept of being outside an employer-employee traditional relationship. What that would mean is that somebody who is working without a formal employment contract could be a gig worker. A home-based worker is somebody who is engaged in the production of goods or services at home or any other premises for money whether or not the employer provides the equipment. Platform workers, again, are workers who are using an online platform to provide services for activities that may be notified by the government. So it is really capturing almost about, I think loosely what I read in the report, about 25 to 30% of a workforce that has so far been highly unregulated in India. The central government has, the code talks about various funds and schemes that will be set up now to take care of the unorganized sector. There are central government funds that talk about life and disability cover, old age benefits, education, things like that. State government schemes, again, that the state government has the liberty to set up. And what it says, it may set up. So, again, there is a lot of control that's being given to the government to figure out how they want to do it and how much they really want to put into this coverage. So, when on one side, when you're talking about social security coverage for the unorganized sector, the parameters have not been very well defined. There has an onus has also been placed on aggregators when we're looking at online platforms. The digital intermediaries or marketplaces who are using, they are now have a requirement to be more careful and to contribute towards social security for their workers. The contributions to these funds, to the government funds and the schemes, will be 1 to 2% of the aggregator's turnover, which can go up to 5% of the wages paid out to these workers in the unorganized sector. So there is a firm placement or requirement for aggregators to now be more socially and morally responsible for their workers. It's a good move. It's a good move. We just need to see how this is going to play out and how the funds and schemes are going to be made effective. That's a good part about it. The not so good part about it is the requirement, and again, this is something that I see. Now, to take advantage of the social security contributions in the unorganized sector, you need to be registered. There is an age criteria. You need to be 15. I think it's 15 when you need to register. I know, maybe it's 18. I can't recollect off the top of my head. But it's an online registration for which an Aadhaar card is required. So this would mean that if you don't have an Aadhaar card and you don't have access to an online registration portal, and you may not be the most educated unorganized worker, you may not be able to gain the benefit of this. These are aspects that need to be streamlined, need to be ironed out, and it is up to the government to see how they'll do that. Again, great parts are electronic filings all over the place. You don't have to look at massive red tapes. And a lot of that has already moved, especially in the EPF, ESI, all of those sectors. Everything has gone online, It's recognized now. Penalties, again, have gone up substantially, but the compounding process is available. Like I mentioned earlier, pandemics have been recognized. I think this is something that it's very interesting to see. And this is something that I've been discussing a lot when I've been speaking with clients, is that nobody envisaged a situation where there's remote working for so many months. So the government now has actually brought in the fact that they can look at epidemics and pandemics and defer or reduce contributions for PF and ESI up to 3 months. As we've seen earlier, that has been extended over this year. Another good aspect, another thing that I think that will work in employers' favors is that employers have now been given the opportunity to correct non-compliance within a specified time period before prosecution actually kicks in. Like Suhas mentioned, that's a very important thing because we're looking at technical issues. I mean, hopefully not moral or human right issues where you're actually not paying your workers or you're not, deliberately not paying them the required contributions and taking care of them. But if it's something like a technical aspect about not filing a return on time, at least you're now going to get an opportunity to correct that before you go for prosecution. And compounding, again, exists under the Social Security Code as it does exist under all the other codes. Okay, yeah, I think I'm okay on time here. I know I did rush through a little bit of it, but it's a really, really broad matter to discuss. And I've touched upon the main laws that will impact or with the audience currently here.
Thanks, Devjani. I guess the thing that's most interesting in this code is the applicability to gig workers, platform workers, home workers. So do I understand correctly, platform workers, the platform has to pay 1 to 2% of their turnover to a government fund, and then somehow the government is going to provide some kind of social security to those workers?
So yeah, so it's going to be a combination. So the social security coverage is going to be a combination from the aggregators as well as from the government. So very interestingly, wherever you're putting fines in for compounding and other things, that also goes into the social security fund. So that's a good point. So you know where your money is going. At least it's going to hopefully take care of the unorganized sector. But right now, it is a combination of government funded schemes as well as a combination from the aggregators.
Okay. And in the last couple of years or so, we've had this issue concerning creches under the Maternity Benefit Act. So do I understand correctly now you can just use a private creche, and does it mean a business has to just assign X amount of money to a woman worker and say that, you can take that money and go and, get any creche you want? Or do they have to provide a bill that they're actually paying for it, or how does that work?
The rules aren't clear on this yet, Stephen. The rules came out a couple of weeks ago, I think on the 13th of November. So what they say is that, yes, of course, you can use a private creche, but the modalities of whether you can reimburse a woman taking advantage of the creche is still not clear. Practically, I think it should be okay, but the rules they haven't talked about it. They talk about an onus on the establishment to provide that facility. So
Okay.
it's not very clear. Again, the rules are messed up a little bit about, like I mentioned, on urban areas, rural areas. If you've got a 15-minute nursing break, stretchable to 30 minutes, and the creche needs to be what the rule says at an appropriate distance from the workplace. What is an appropriate distance? In Bangalore, the appropriate distance, you're not going to get anywhere in 15 minutes unless it's in-house. So again, those are things that we will now need to look at the state governments to hopefully streamline a little more, as we've seen in the Karnataka's already got, has got rules to the Maternity Benefit Act, which talk about distances and aspects like that, safety, security. So we'll have to wait and see how the state governments work on this aspect.
Okay. So with that, we'll move on to the fourth code, which is the Occupational Safety, Health and Working Conditions Code. And I'll ask Suhas to talk about that. Suhas, you're on mute.
Yeah, okay. So can you hear me now?
Yes.
Okay. I just projected my screen as well. Can you see my screen as well?
Yes.
Oh, great. Okay. So yeah, this is a very important development. The OSH code, as I like to call it. In the US, they have a better term for it called the OSHO Act. So I like that term. This law actually, consolidates 13 different legislations. I think key for this audience will be the Factories Act and the Contract Labor Regulation and Abolition Act. I think those are the two main legislations that the audience would be interested in. The other 11 legislations relate to employees who are working in construction sites, in mines, journalists, and so on and so forth, but perhaps not so relevant for this audience. Now, the first key thing that I noticed in this new code is that usually the Factories Act, which deals with working conditions, safety, what kind of facilities needs to be provided to employees, and so on. The similar requirements have now been made applicable to all establishments in which 10 or more workers are employed. So I would think that this law would now be applicable for even commercial establishments, companies in the IT, software development sector, and so on, banks. So I think almost all service sector industries would also now be covered under this legislation. One irritant we may feel initially is that there may be a little bit of overlap with the Local Shops Act applicable in each state and the OSH code. So we will have to wait and see how this will play out in the long run, where the states will now harmonize their legislations by changing them to make it in compliance with the OSH code is something that we will need to wait and watch. In terms of how this code is structured, there are various chapters to this code. So there is a specific chapter which applies to factories, a specific chapter which applies to construction workers, a specific chapter for contract workers, and so on and so forth. So in terms of readability, it's kind of easy to read and digest the applicable provisions. It's not very confusing like earlier. So I must say from that perspective, it's good. The thresholds for applicability have also been increased. Under the Factories Act today, the threshold was 10 workers without the aid of power, or 20 workers with the aid of power. So that those thresholds have now changed to a factory which employs 20 workers using power, or 40 workers without the aid of power. One key change that I see is that a state government may exempt a factory from the applicability of the OSH code, just like how Devjani covered it in the IR, the Industrial Relations Code. A government can now exempt a factory from the applicability of the code. And the reasons given, in addition to public interest under the IR code, are also to create more economic or employment opportunities. So it's a very interesting concept. We have to see how this plays out. Which state will now be first out of the gate to try and use this exemption? So we have to see. The other, the kind of problem I see with a provision as broad as this is that states may actually become hesitant as well. They don't want allegations that some corruption has been undertaken because of which a factory has been exempt. So I think either states will be first out of the gate or will actually not use this provision. So that's a very interesting provision that I saw. Under the contract labor provisions as well, the thresholds have been increased. Today, the Contract Labor Act applies for a principal employer which has 20 or more workers through contractors, or for a contractor who has more than 20 contract workers. These thresholds have now been increased to 50. The number is significant, though I think if they had kind of increased it to maybe even 100 or more contract workers, it would have been an ideal situation. One heartening thing is that now for these 13 different legislations, there is just one common registration, but certain aspects like a factory will require additional licenses. Under the existing Factories Act, the provisions which relate to occupier of a factory, owner of a factory, and so on still continue to apply. So there's not been much change from that perspective. There is a mandatory registration requirement that has been introduced. So all existing establishments will have to register under the code within 60 days of its commencement. So I think, if the legislation does come into force on April 1st, so we may be looking at May end or so, by when all establishments should file the online application and get registered under the OSH code. A very interesting provision is that it says you cannot hire employees unless you complete the registration. So hopefully, there'll be some exemption for this for existing establishments as and when the new law comes into force. But this is a very key point to note for employers. Another interesting provision that I noticed is that there is change in control restrictions and reporting requirements introduced by the code. So if there's any change in ownership or management, then there is a mandatory reporting obligation to the authorities. Now, whether this covers an indirect indirect change in ownership, like change in shareholding, whether that is covered, or even if one director resigns, whether the reporting requirement is triggered or not needs to be seen as and when the law is implemented. The other key change to highlight is that any closure of an establishment should now be reported within 30 days to the authorities, along with a certification that all employees' dues have been satisfied. Now, this was I think kind of missing in the previous in the existing laws. So this key change is to be noted by all employers, especially the certification that all dues have been paid. Another key change that I noticed relates to people who are supplying articles to an establishment. So this, let's say air conditioning vendor who supplied HVAC equipment to an establishment should now certify that his equipment is safe for use and will not cause health hazards to workers in the establishment, which I thought was a very interesting which was a very interesting change. And I went back and I checked, and such a similar obligation exists in the American regime as well under the OSHO Act. Another key change is issuance of appointment letters. Usually SHOPS Act, at least in Karnataka, the SHOPS Act requires that appointment letter should be issued to each employee. And now a central legislation has now imposed this requirement. There are certain mandatory items to be mentioned in the appointment letter as well. So this, now more or less these practices will become across the board and on a pan-India basis. A key change that has been introduced is to provide free annual health checkups to workers at the cost of the employer and at intervals that are regular. Employers also now need to report deaths or serious bodily injuries that occur at the workplace, serious bodily injury has been defined to mean if an employee is not able to work for a continuous period of 48 hours or more after suffering the injury at the workplace. So these are some very important changes to safeguard health and safety of workers, but at the same time imposing stringent compliance requirements on employers. Today, I think employment of women at the workplace during nighttime is prohibited. In certain sectors like the IT and ITES, it has been permitted subject to certain conditions to be met. You can do it in Bangalore, you can employ women to work in IT companies during the night, but now women can work in factories as well, but they need to consent to work during the nighttime. And overtime working by workers is also permitted, but again, subject to prior consent to be obtained. The same sanitation requirements that were there in Factories Act have been carried forward, but a very interesting change is that separate arrangements need to be made for transgenders. So in terms of additional costs that may need to be incurred by factories to accommodate facilities for transgenders may be a cost that will need to be taken into consideration. So some thresholds which existed earlier have now been reduced, again with the intention to provide a better, safe working environment for workers. So for example, welfare officer in a factory is now required if it employs more than 250 workers. The earlier threshold was 500. Canteen to be provided if they have more than 100 workers. The earlier threshold was 250. Creche to be provided if they have more than 50 workers. The earlier threshold was actually 30. So this seems to be in favor of the employers actually. Now coming to contract labor, I think the first thing to mention is that, there is, the law now permits contract labor in core and perennial kind of activities. The earlier regime, you couldn't actually hire contract labor for activities which were of a core and perennial nature, but the new law provides for it specifically, but subject to certain conditions. And as I mentioned earlier, the threshold is also increased. But one problem that seems to be there is in the definition of contract worker itself. So the definition of contract worker now has an exclusion whereby employees who are getting regular increments or are subject to certain terms and conditions of employment are not deemed to be contract workers anymore. So perhaps this means that you cannot have contract workers working on a long-term basis. So the intention seems to be that if you're providing increments, then they should be considered as regular employees. Now, the question is regular employees of whom? Is it a regular employee of the contractor or regular employee of the principal employer? So this question has not been addressed in the new legislation. A very key change that I see in the contract labor regime is that now the law says that if a principal employer employs contract workers through an unlicensed contractor, then such employment is deemed to be legal. And while it is not clear what the implication could be, the implication could be that such workers could now be deemed to be employees of the principal employer. This is a very key change. While the new law requires principal employer registration and contractor licensing, like earlier, a key aspect has been introduced for employers, principal employers who take in workers through unlicensed contractors. In terms of another very key change that I see is now with the tribunals to be implemented across the different courts, the jurisdiction of regular civil courts have now been barred. The OSH Act specifically has such a provision. In fact, the specific requirement there is that no civil court can grant an injunction for a matter covered under the OSH code. I think this perhaps has to, the reason for this could be twofold. One, the establishment of the tribunals. Two, the fact that the government wants more regulatory control through the inspector cum facilitators that will be appointed. So that is what I think will be, is the intention behind barring civil courts jurisdiction. The compounding of offenses that I mentioned earlier, which Devjani covered, is covered under the OSH code as well. The penalties have been substantially increased from the existing regime. Interestingly, there's a penalty on employees for not following health and safety requirements as applicable under the code and as implemented by the employer. So employees can now be liable for a penalty of 10,000 rupees for not following health and safety requirements. So in brief, that's really what the OSH code covers. This code is probably the most lengthy of all the codes, and the rules also seem to make it very lengthy. So I think, in terms of compliance, companies really need to be very careful with how they comply with this code. Back to you, Stephen, as the moderator.
Thanks, Suhas. As you know, the IT industry employs a fair amount of workers through contract workers as part of their staff augmentation. So it appears it's not free for all, right? You can't just go and get anyone as a contract worker, hire them through a contractor. There are conditions attached, and there are certain, if you do things in a certain way, it may not work out, right?
That's correct. So as I said, I think today there are manpower supply companies. There are manpower supply companies who are not registered under the Contract Labor Act. and was applying labor. So one thing the code will really weed out is unlicensed contractors. So that is not at all permitted. That's the first. Response. The second thing is, in terms of allowing core activities to have contract workers, the intention seems to be we will permit it, but you need to comply with the specific requirements that the law will impose. So I think it will be difficult going forward to use unlicensed contractors or to hire contract workers directly. But as long as you are within the ambit of the law, I think things will be easier for employers.
Okay. What so do you see this this code as really taking things forward, or is it more of the same thing?
It's more of the same thing, and in fact, I think this is probably the code which will, in my view, attract a lot of controversy in the days to come. And really, the problem is in the fine print of the law. And I see three major problems under the OSH code, generally speaking. The first is, I think we may have a problem of over-regulation of the OSH code. And the reason I say this is because the last 20 or so sections of the OSH code just deal with the power of the government to frame laws or frame rules. So I'm afraid that we may go down the path of the Companies Act under the OSH code, where there is one section, but 20 different rules framed under the rules, which cover on that one section. So I'm afraid we may get into a situation of over-regulation under the OSH code. The second problem I see is a problem of harassment. While it's great to move towards web-based resolution, web-based inspections, and so on, the government has retained the power with the inspectors to undertake surprise checks on factories and establishments. Now, it seems to be that the government wants to give in one hand, but take it away in the other hand. So I'm afraid, this power of surprise check may be misused by overzealous inspectors and may actually cause harassment to employers, which is more of the same thing, to your point. The third problem is something that I covered initially, which is the problem, the power given to exempt for employment opportunities. So whether governments will be unbiased, will exercise this power in all fairness, so that they don't go and try to pull points. My state is better than your state, so I will grant exemption for a certain category of establishments, certain categories of factories. I hope governments don't do that. They shouldn't indulge in one-upmanship, which can be counterproductive in the long run. There may be worker dissatisfaction, disregard for health and safety of workers. So that shouldn't become a stumbling block when governments try and use this power that is given to them. They should use this very judiciously and very carefully, is what I suggest. So I do see a lot of problems under the OSH code, Stephen.
Okay. We'll take a few questions. I've got questions from participants when they're registered, as well as those who have posted online. The first question relates to the 50% wages rule, that the wages must be at least 50% of total compensation. And the question really is, do corporates now need to restructure compensation packages? And what happens with something like overtime, where overtime changes from month to month, depending on how much you worked? What happens then?
Yeah, I think the first first aspect, I think companies will need to relook at their overall compensation structure. Because I think what I see in the industry is basic wages may cover maybe 30 to 40% of the CTC. So if there is a deeming provision whereby more than 50% will be considered part of wages, I think companies do definitely need to relook at that, because several components like overtime payment will trigger based on what is wages. So I think there's a serious need to relook at overall compensation packages. On the overtime aspect, I have the same thought. I think we will need more clarity. But today, what the Central Act wants to do is stipulate the minimum overtime payment. So I think the implementation will be left to the next stage. So what I mean by that is, for say in the agriculture sector today, the overtime is 1.5 times the wages, whereas some states say it should be 2 times the wages. So the center wants to create the threshold of being at least 2 times, and then leave the further implementation to the next stage is what I think.
So if wages is going up in relation to total compensation, then I guess Provident Fund will also go up, right?
Yes, correct. So though I don't have it handy with me, I think there's a slight change between wages under the Social Security Code and the wages as defined in the Code on Wages. But yes, it will have a direct impact there. Yes.
Okay. So that's that may be a cause of worry for those who are more focused on take home. In my experience as an employer myself, a lot of people focus on take home rather than the total compensation. There are some questions on gratuity as well. One of them is, how does gratuity apply to fixed term workers? So gratuity is for 5 years. If you worked for 5 years, it could be for less in some scenarios. But if you're a fixed term worker, you worked for, say, you've been renewed 4 times and you finished 5 years, then what happens then? And again, how does it work for payment where there's bonus? So you're going to pay gratuity within 30 days of leaving, and then bonus may be determined a few months later depending on performance of that particular business unit. So how does that work?
Okay, so what I'll do is I'll break down the questions. The first one on the fixed term employees. Very importantly to remember here is that while the Social Security Code says that gratuity is payable without the 5-year requirement for fixed term employees, the Industrial Relations Code actually says a gratuity is payable after completion of 1 year. So that is a classic example where there is a dichotomy between the two codes. Going strictly by the Social Security Code, it would mean that fixed term employees are eligible to receive gratuity irrespective of their tenure, whether they've worked a year. Again, when we're looking at gratuity, remember gratuity is calculated at 15 days for every year worked. So we're looking at the presumption that the worker should have at least done 240 days or 190 days of work with the employer, even on a fixed term basis, to be eligible for gratuity. Now, the second aspect that was about how do you pay out gratuity when it includes components like bonus, commission. I also saw a question on whether there's ex gratia ex gratia gratuity ahead of the ceiling of 20 lakhs that's currently there. Now, if you're paying more gratuity by way of agreement with your employee, then that's fine. Do you need to stick to the definition of wages under the Social Security Code for that? Traditionally, we have been following that approach even in ex gratia, better gratuity terms. So my assumption is the same principle would apply. Regarding the aspect about whether bonuses and commissioners, a delayed payout of bonuses and commissions in the computation of the gratuity, that is something that would depend on the specific bonus and commission term. Strictly speaking, if gratuity needs to be paid out in 30 days, your bonus commission plan will somehow need to factor in this aspect, and the employees need to agree to the fact that there may be a deferred payment. we would really need to look at the specific bonus plan to see how to work on that.
Okay. Dejani, I saw something on home workers, and I think that will cause alarm to all households where you have, a maid or a watchman, a driver, and so on. So what is the actual requirement? Is every household in India going to need to be registered or?
Okay, so Stephen, there are two ways about it. Would I like them registered? The answer is yes. Does the law require them to be registered? The answer is it's not very clear. So what a home-based worker has been defined is, and what the code says, it is a person who is engaged in the production of goods or services for an employer in his home or at premises of the worker's choice other than the workplace of the employer. So is a domestic assistant or a domestic help actually producing goods or services for me? Probably not. I think the home-based worker concept in the unorganized sector is actually looking at employees or individuals who are producing goods or services for consumption in the domestic and local market, but working from home. It literally is, it is, my understanding is it's limited it's limited to workers who are working under the subcontract mechanism for various global value chains, because things along those aspects are where home-based workers are, rather than domestic help is my understanding. We will need to see if the government actually comes out and says that they are covered as actually producing goods or services for an employer.
Okay, so it's not really covering personal services. It's more about people working for home for a particular business.
That's right.
Okay. I'm just going to see if there are any new questions in the last couple of minutes. Someone is asking again about working from home, whether there could be a kind of discrimination between people working from home versus people working from office. Would the rules be different, and would compensation in particular be different?
Okay, there are two aspects here. Are you working from home as a mainstream employee, or are you a home-based worker? Now, if you're working from home remotely, but you are a regular employee, then there really shouldn't be there should be no difference whether you're working in a physical office or whether you're working from home. Home-based worker is a completely different concept which falls under the unorganized sector.
Okay. Can I request one of you to put the presentation back on? We'll just run through the conclusions, and I'd like each of you to just spend a minute maybe telling us what you think are the key conclusions that you see from this, and I'll ask Dejani to start first.
I think Suhas had certain points flowing from his discussion when we talked about the fact that these are labor law reforms of the kind that India has not seen in decades. Now, the good parts about it, of course, are streamlining of all of the laws into the four specific codes. It makes it easier from a compliance perspective. Also, in keeping with the spirit of the law of the codes, it definitely seems to actually help the employer-employee relationship. It definitely is a move towards increasing economic stimulus in the country to increase better more recruitment, more job opportunities, things like that. Those are, in my opinion, flowing from the industrial, the codes that I've covered. Those are really, really important aspects. There continue to be drawbacks, several distinctive, when we're talking about, again, let's go down to starting from hiring and firing. Hiring has been streamlined. Firing pretty much remains the same, other than an increase in the threshold for a limited number of establishments. So as such, there has been no substantive change under the four codes, under the to actually how you hire or fire. There have been compliances that have been introduced by way of requirement of an appointment letter, things like that. But actually, there have been no substantive changes as such. For me, big issue, and this is something that we've discussed earlier, continues to be the requirement of government approval for firing a worker that you may not be happy with in, say, a manufacturing facility. That continues to be an issue.
Right. What about you, Suhas?
So, sorry to go back again to the regulator. It's a great thing that 44 or so legislations have been condensed to 4 legislations. Makes my job and your job as a lawyer easy, because we now have to just look at 4 different law books. But the problem, and it's the intention is all driven by we want to make India a hub for manufacturing. We want to create more job opportunities because we have several million people in the age group of 20 plus who are entering the workforce every year. We need to keep them occupied and so on. So that's the intention behind all these changes. That's the driver. But when I look at these provisions as the regulator, the labor inspector, the labor authority sees that, not much has changed. They put everything in one legislation. So will he change his mindset when it comes to interacting with employers? Will he create more problems? Will he create the same amount of problems, or will he create less amount of problems to the employer? I think that's really the challenge in my mind, if you ask me, because unless the inspectors, the people who implement these laws on a daily basis, change their mindset of how they look at implementation and compliance, not much may be achieved on the ground with these new 4 laws. Is my concluding remark, really, and that's really on top of my head, actually.
Right. Yeah, I mean, I think this is really seems to be more about simplification and rationalization rather than an overhaul or, what I call a kind of paradigm shift. And it's disappointing to some extent because we are seeing, US multinationals who are looking at diversifying out of China. And the talk is India could be one destination for that, mostly because we have a large market. So we really want to try and become more attractive. So lack of hire and fire, government approvals, and generally still a fairly over-regulated regime is somewhat disappointing, given, of course, there are some gains from these codes. I think with that, we conclude our session. I'm going to turn this over to Jose Jacob of Integra Infotech. He's the Senior Vice President of the Indo-American Chamber of Commerce, to give us his concluding remarks.
So thank you, Stephen, and all the speakers. I think it was really wonderful to go through this webinar. Many of us have been facing a lot of uncertainty in these days, and now there is a new spin and there's a new uncertainty that we have to manage. Anyway, 2020 is a year full of surprises. I hope we can say by the end of the year, some surprises were pleasant, but we have to wait and watch. So I would like to quickly, do the vote of thanks and thank all those people who, put their efforts to make this webinar possible. So firstly, I would like to thank Kocher & Co. Kocher is one of the leading law firms in India, also in South Asia. They have locations all over India, also outside India, in Dubai, Singapore, Atlanta, Jeddah, and also in Saudi Arabia through a connected entity. They're helping many of the Fortune 500 companies. So thank you so much, Kocher & Co, that you are partnering with IACC to host this webinar. Special thanks to Stephen for moderating very calmly and precisely throughout the whole panel. Special thanks to Suhas and Debjani. I think you tried your best to keep a balanced view, not criticizing too much what's going to unfold. Nonetheless, I think many members know whom to call as the new law unfolds. I would like to thank especially our chairman, Shyam. He has been chairman recently, and now taking up this initiative to motivate us to do as much as possible for the branch so that the member companies can grow. I think already companies have faced a lot of uncertainty in the last months, and I think a prepared mind and a prepared plan equips us better to face further more uncertainty to come. So in that context, thank you, Shyam, for your leadership to get this webinar done this year itself, so our members get time to prepare. And in the success of our members lies also IACC's growth and success. So thank you, Shyam, for that. Special thanks to Jitika and Sujata. They have done all the background work. If you saw that everything went seamlessly after 100 people on Zoom, then it goes to YouTube, and everybody has been able to listen and take their important notes. Thanks to Jitika and Sujata, and also the national office team to help set up everything seamlessly. How can we end without thanking all of you who attended? Very, very interactive with all the questions, clarifications. In a way, it's difficult to speak just to a screen. It's not the normal thing that we're used to, but it keeps the speakers aware that there are a lot of people listening to every word that they're saying, or observing every word that they're not saying, and therefore trying to latch on to as much stuff that they can get. Well, I want to end this day with a quote by Elizabeth Edwards. She said something very interesting about resilience. Resilience is accepting your new reality, even if it's less good than the one you had before. You can fight it. You can do nothing but scream about what you've lost, or you can accept that and try to put together something that's good. So I think what this session has done for each of us is try to prepare for whatever is coming. Of course, the press and all the noise that will surround the new law will give us a little bit advantage, because we already have some holding over what's going to unfold, and therefore we can interpret it better as the arguments take shape. So thank you all for joining on this call. And also I want to end with a short announcement. We at IACC want that our members can grow, connect, collaborate, and continue to do business even though the times are tough. So at IACC, our next event is the JES Confluence, which IACC is a partner, which is the Global Economic and Sustainability Confluence. Jitika would have already sent you some information about that. It's a good opportunity to connect, network, and grow your business. Once again, thank you everyone for attending, and thank you Kocher and Co, especially also on behalf of the chairman and our IACC committee and branch committee of Karnataka. And look forward to staying in touch. And we hope that when our members face some problem, we can reach out to you also for some pro bono consulting, at least in the beginning. And then if there are big problems, you can solve it case by case. So thank you very much to everyone. Have a nice evening, and wish you a great weekend as this week ends. Thank you so much.
Thank you.
Thank you.
Thanks, and good night, everyone.
Bye.
Bye-bye.